The mask of trust. There's a specific kind of predator that law enforcement describes as the hardest to catch. Not because they are physically dangerous, not because they operate in the shadows, but because they operate completely in the open. They stand at the front of a classroom. They hold award certificates. They smile at parent-teacher conferences and send encouraging messages and remember every student's birthday. They are the trusted ones, the ones parents specifically thank by name in graduation speeches. And they use every single piece of that trust as a weapon. Today's episode covers 4 cases of female predators who held positions of authority over children, used those positions methodically and deliberately to isolate and groom their victims, and were ultimately brought down by the detectives and legal systems that exist specifically to protect the people they had targeted. These are not cases involving physical strangers or parking lot encounters or internet predators operating from unknown addresses. These are cases involving women who have been hired, vetted, credentialed, celebrated, and trusted by the communities and school districts and families whose children they were paid to protect. Women who, in multiple cases, had been recognized for their professional excellence before they were arrested for betraying the most fundamental responsibility that recognition was supposed to represent. In the United States, women account for approximately 22 to 30% of all documented cases of educator misconduct with students, a figure that has consistently surprised researchers and law enforcement professionals alike, because a cultural assumption that female teachers present less risk than male ones is precisely the assumption that allows certain cases to go undetected for as long as they do. Administrators who receive student reports about a female teacher are statistically less likely to escalate those reports immediately. Parents who are told their teenage son may have an inappropriate relationship with a female teacher are more likely to minimize what they are hearing. And the predators who understand this, who deliberately leverage the assumption of safety that comes with their gender and their credential, use that minimization as part of the strategy. 4 cases, 4 women, 4 law enforcement investigations that ended the same way, regardless of how long the crimes went undetected. In handcuffs, in courtrooms, in sentences that followed each of them into the correctional system with their names permanently attached to the sex offender registry. Before we get into the cases, it is worth understanding what investigators mean when they use the word grooming. Grooming is not a single act. It is a process, sometimes weeks long, sometimes years long, designed to establish trust, create dependency, and build a private communication channel with the victim while systematically removing the protective barriers between the predator and the child. The American Bar Association describes it as a preparatory process in which a perpetrator gradually gains a person or organization's trust with the intent to be sexually abusive. The key word in that definition is gradually. Gradual enough that no single step looks wrong on its own. Gradual enough that the parents, administrators, and fellow students around the predator and the child often don't recognize what is happening until it has already been happening for a long time. The 4 women in today's episode were all in what law enforcement calls positions of trust, the legal designation that applies to teachers, coaches, counselors, and anyone else whose professional role gives them formal authority and supervised access to children. A position of trust is supposed to be a protective structure. These 4 women turned it into an instrument of access. Let's go through them one at a time. We start in Arizona in 2018 with a parental monitoring app that changed everything. Before we get into the first case, I want to ask you something that shapes how we understand everything that follows. When you picture a predator grooming a child, what does that person look like in your head? Hold that image, because what you are about to hear will challenge it in every single one of these 4 cases. Drop your honest first instinct in the comments. The app that caught her. Goodyear, Arizona, January 2018. A 6th grade teacher starts messaging one of her 13-year-old students through a classroom educational app. The app is called Classcraft, a legitimate tool used by thousands of teachers, designed to gamify learning. She tells her class to message her through it because she will be absent the next day. The 13-year-old messages her as instructed. She responds. The conversation moves from the classroom app to Instagram, from Instagram to Snapchat, from Snapchat to explicit photographs. From explicit photographs to physical encounters in her car, in her classroom, and elsewhere. The boy is 13. His teacher is 27, married, and had been named Teacher of the Year at her previous school. Brittany Zamora graduated from Arizona State University with honors, a 4.0 student pursuing both undergraduate and graduate degrees in education simultaneously. She took her first teaching job at Littleton Elementary School in Avondale, where she quickly impressed her colleagues enough to be selected as Teacher of the Year in 2016. That recognition followed her to Las Brisas Academy in Goodyear, where she was recruited by a former administrator who had moved to that school and specifically wanted her there because of how well she worked with students. She was exactly who she appeared to be on paper. Educated, enthusiastic, award-winning, recommended by administrators who believed in her. And she used every part of that profile, the trust it generated with parents, with the school administration, with the students themselves, to operate in plain sight for months. The grooming begins. The relationship with a 13-year-old victim began through the classroom app in January 2018, but the groundwork had been laid before that. Zamora had been paying particular attention to the boy for some time. She used the tools she had available, a school-issued classroom communication platform, a teenager's natural desire to feel seen and valued by someone who held authority in his world, to begin a process that investigators would later characterize as methodical and deliberate. Once the conversation moved off the educational platform and onto personal messaging apps, the content changed rapidly. She sent him photographs of herself. She asked for photographs in return. She arranged to meet with him in her car after dark. She texted him to leave his grandparents' house after midnight for one of these encounters. She had contact with him in her classroom on at least one occasion, during which he positioned another student, an 11-year-old friend of the victim, outside the classroom door to watch for staff. That second student later told police that Zamora had also sent him explicit photographs of herself and had made attempts to groom him as well. That second student's account is one of the details in the Zamora case that stops investigators cold when they review it. An 11-year-old child standing outside a classroom door, serving as a lookout because his teacher had positioned him there, not fully understanding what he was standing guard over, just doing what the trusted adult in his life had asked him to do. How she was caught. On March 21, 2018, the victim's father and stepmother made a discovery that would end Brittany Zamora's career, her marriage, and her freedom. They had installed a parental monitoring application on their son's phone, the kind of app that alerts parents to concerning content in their child's messages. The app flagged what it found. The parents looked. They saw everything. They saw the explicit messages. They saw the photographs. They saw the record of what had been happening between their 13-year-old son and his 6th-grade teacher over the preceding weeks. They contacted the Goodyear Police Department. Investigators were working the case the same day. And in the immediate aftermath of those calls to police, something happened that prosecutors would later describe as deeply revealing about Zamora's character. She began calling the victim's family directly. She called multiple times, attempting to talk them out of reporting what they had found. She was trying to convince the boys' parents not to tell police about the evidence they were sitting on. The calls did not work. The Goodyear Police Department arrested her. She was charged with 15 felony counts. The school where this happened reportedly received written complaints from multiple students about the relationship between Zamora and her victim approximately 6 weeks before her arrest. The principal acknowledged those complaints but did not immediately contact law enforcement or the victim's parents. 43 days passed between that report and the arrest. What do you think should happen to schools that receive student reports about inappropriate teacher-student relationships and fail to escalate them immediately to police? I want your view in the comments. Asterisk, 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 asterisk. The courtroom. Brittany Zamora took a plea deal in June 2019. She pleaded guilty to 3 felony charges: sexual conduct with a minor, attempted molestation of a child, and public sexual indecency. 12 additional criminal charges against her were dismissed. The plea agreement specified a minimum sentence of 20 years. On July 12, 2019, she stood before Maricopa County Superior Court Judge Sherry Stevens. She was 28 years old. She addressed the court and said she was ashamed of her actions, that she was remorseful, that she was a good person who had made a mistake. She said she was not a threat to society. The victim's mother's written statement was read into the record by the family's attorney. She said she hated Zamora for what she had done to her child, and that her son had been changed forever. A civil lawsuit filed by the family against the school district, against Zamora's husband, and against the principal alleged that the district had delayed action on student reports and that the principal had not immediately notified police. Zamora's husband would later settle his portion of that lawsuit. Judge Stevens imposed a minimum sentence, 20 years. Under Arizona law, Zamora is required to serve at least 80% of that sentence before any release consideration, placing her earliest possible release date at 2038. She will be required to register as a sex offender for life. A follow-up report from a legal news outlet in 2021 found that while inside Arizona State Prison Complex Perryville, Zamora had been assigned to work as a tutor and educator for other inmates, an assignment she had requested and which was approved because she had no disciplinary issues during her incarceration. The story generated significant public outrage. Prison officials defended the assignment as following standard protocols. The Arizona Department of Education confirmed her teaching certificate had been revoked. The 13-year-old boy whose teacher invited him into a classroom chat app one January morning is not a child anymore. He was 13 when this started. He was approaching 15 by the time the plea was entered and the courtroom proceedings were underway. The lawsuit his family filed included testimony that he had begun to view women differently as a result of what happened, that his relationship with trust in general had been fundamentally altered. There is no criminal sentence that repairs that. The 20 years was what the law could offer. What it could not give back was a version of that boy who walked into that school year without this as part of his history. Fortnite, Snapchat, and a child. Covington, Tennessee, August 2023. Administrators at Charger Academy, an elementary school in Tipton County, are informed of allegations about one of their fourth-grade teachers. Her name is Alissa McCommon. She is 38 years old. She has built relationships with her students' families, been inside their homes, had the mothers of her victims trust her, like her, invite her into their lives. Within days, the Covington Police Department has arrested her. By the time the investigation is complete, detectives will identify 21 potential victims ranging from 12 to 17 years old. And DNA testing will confirm that one of those children, a 12-year-old boy she had been calling over 200 times and pursuing through Snapchat for more than 2 years, is the biological father of the child Alissa McCommon is carrying while sitting in jail awaiting trial. A 12-year-old victim, a child she started pursuing when he was in her class. A pregnancy confirmed by DNA to have resulted from the abuse of that child. A baby that a Tennessee court would eventually rule McCommon could have absolutely no contact with, because the baby's other biological parent was her victim. This is one of the most extensively documented, most procedurally complex, and most deeply disturbing educator abuse cases in Tennessee's recent history. The method, video games as a gateway. The Covington Police Department investigation revealed a consistent pattern across multiple victims. McCommon would begin by playing video games with them, specifically Fortnite, the online game that draws enormous numbers of young teenagers worldwide. She would befriend her victims within the gaming environment first. Then she would move the conversation from the game to social media. From social media to Snapchat, the platform whose disappearing messages made the contact harder to trace. And from Snapchat to explicit photographs and then to physical encounters. In parallel with the digital contact, she worked on the parents, the mother specifically. McCommon was warm, attentive, and present in a way that the families of her victims found disarming and reassuring. She had been inside their homes. She had been trusted with their children not just in a classroom context, but in personal contexts, the kinds of extended access that teachers rarely have, but that McCommon had cultivated deliberately as part of how she operated. The investigators examining her phone found over 200 calls to her primary victim, the 12-year-old boy she had been pursuing since he was in her class. They found explicit photographs. They found a record of a relationship that had been ongoing for more than 2 years before the arrest, a timeline that began when the child was approximately 10 or 11 years old, and she was in the process of grooming him, well before the abuse became physical. The arrest, and what she did after. McCommon was arrested on September 8, 2023, after the Covington Police Department received a formal complaint from a parent. She was taken into custody, charged with child rape and multiple counts of sexual misconduct with minors, and released on bond. Less than 3 weeks later, she was arrested again. While out on bond, she had contacted one of her victims using a previously unknown phone number, a number not disclosed to law enforcement during the investigation. According to police, she sent a message to the victim using a code word from their previous communications, a code used specifically to confirm, before sending explicit content, that the child was alone. She used that same code word again. She sent messages telling the victim he would regret what he had done by reporting her. She also told him, through those messages, that she was pregnant with his child. The threatening text exchange was recorded and played aloud in open court at a hearing in October 2023. Her defense attorney told reporters the voice in the call was not hers and that the messages could have come from anyone, pointing out that the number was not registered. She was rearrested on September 28, 2023. This time, bond was denied. She remained in the Tipton County Jail through the subsequent months of investigation, hearings, motions, and a grand jury process that returned a 23-count indictment in March 2024 covering charges including rape of a child, multiple counts of aggravated statutory rape by an authority figure, sexual exploitation of a minor by electronic means, solicitation of minors, tampering with evidence, coercion of a witness, and aggravated stalking. McCommon was out on bond after her first arrest and immediately contacted one of her 12-year-old victims through a secret phone number, used their established code word, and threatened him. What does that tell you about how she viewed the situation she was in? Do you think she fully understood the legal consequences she was facing? Or was she operating on the same instinct that had driven everything that came before it? Tell me what you think. The DNA confirmation. Among the most unusual elements of the McCommon case was a DNA testing that confirmed her primary victim had fathered a child with her. McCommon had told the boy about the pregnancy through text message before her rearrest. She gave birth while in custody. The Tipton County Circuit Court issued an order. McCommon was to have absolutely no contact with the infant child. The child was taken in by the victim's family. The boy's mother, who had once considered McCommon a trusted friend, someone she had welcomed into her home, who had befriended her, who had used that friendship specifically to access her son, spoke at the sentencing hearing. Her statement was direct. She said she had loved McCommon like family, had opened her doors to her, and that McCommon had used that friendship to harm the people she loved most. She said McCommon had taken innocence from her son before puberty. She told McCommon directly that the innocent child would be loved and raised without her influence. She then added, in open court, there was no amount of time anyone could give her that would equal what she believed God would eventually deliver. The plea and the sentence. Facing a 23-count indictment and the prospect of what the district attorney's office described as potentially 20 separate trials, McCommon took a plea deal in December 2024, just weeks before her scheduled January 2025 trial date. She pleaded guilty to 1 count of rape of a child, 2 counts of statutory rape by an authority figure, 3 counts of aggravated statutory rape, 3 counts of sexual exploitation of a minor by electronic means, 2 counts of solicitation of a minor, and 1 count of violating the Child Protection Act. 12 additional counts were dismissed. Tipton County Circuit Court Judge Blake Neal sentenced her to 25 years at 100%, no possibility of early release. She was ordered to register as a violent sex offender for life, to undergo community supervision for the rest of her life after release, and to have absolutely no contact with any of her victims, including the infant child born in custody. Her teaching license was permanently revoked. District Attorney Mark Davidson said the convictions and sentence reflected the continuing commitment of law enforcement and his office to aggressively pursue child rape and sexual abuse cases. He said he was grateful the resolution provided finality and closure for the victims' families and the Tipton County community. Alissa McCommon will be in her 60s before she becomes eligible for any form of post-sentence consideration. The 12-year-old boy she called more than 200 times will be a fully grown adult long before any door opens for her. There is a child in Tennessee who will grow up knowing the full weight of this story the day they are old enough to be told it. A child who had no choice in the circumstances of their birth, no agency in what their biological mother did, no say in the aftermath of a crime that produced them as a consequence. The court's decision to order no contact, to place a child in the care of the victim's family, entirely outside McCommon's reach, was the best available legal protection for a situation that had no good outcomes. Only outcomes with different weights of harm attached to them. Teacher of the Year, August 2022, San Diego County, California. 5 teachers from across the region are selected as San Diego County Teachers of the Year, the most prestigious recognition the county's Office of Education bestows on educators. The process is competitive and rigorous. One of the 5 recipients is Jacqueline Ma, a 34-year-old 5th and 6th grade teacher at Lincoln Acres Elementary School in National City, who has been teaching in the National School District since 2013. She is celebrated. She has earned it. 7 months later, she is arrested. The National City Police Department received a phone call in March 2023 from the mother of a 12-year-old boy. The mother had found something on a shared family tablet, a device used throughout the household, not specifically assigned to her son. What she found were messages between her son and his teacher, Jacqueline Ma. Messages that described things a teacher should never have been communicating to a child. The mother was, in the words of the deputy district attorney who later presented the case in court, speechless. She could not believe she had trusted this woman. She could not reconcile what she was reading with a teacher who had been so attentive to her son, so invested in his education, so present in his school life in ways she had understood as dedication and warmth. The mother called the police. The architecture of access. Detective Colleen Stanek of the National City Police Department conducted the investigation and provided key testimony at a preliminary hearing that laid out exactly how Ma had accessed and maintained her relationship with a boy referred to throughout the case as John Doe 1. John Doe 1 was 12 years old at the time of the abuse. His parents had specifically prohibited him from having social media. They did not allow him personal electronics. His access to the internet was supervised. These were exactly the kinds of protective measures that child safety advocates recommend. They were not enough because Jacqueline Ma was on the other side of every one of those restrictions with a specific workaround for each. Ma set up an unsanctioned after-school program at the school, unofficial, not approved by the district, specifically to give herself extended access to the boy outside regular classroom hours. She used the video game chat systems built into gaming platforms the family allowed for supervised entertainment. She used a school-issued communication application as a contact channel. She used every legitimate channel available to her to build a pathway that the boy's parents could not easily detect, because each individual element of it could be explained as normal teacher-student interaction. When Detective Stanek later spoke with Ma directly about her relationship with John Doe 1, Ma's response was recorded and would be repeated in court multiple times. She said, "It is complicated, and I may have blurred the lines." A subsequent search of Ma's cell phone uncovered a hidden application. Inside it, investigators found extensive messages between Ma and the boy. Messages describing sexual acts, messages including explicit photographs of the child, and messages in which Ma described herself as being in love with John Doe 1. Messages in which he expressed grief, in advance, about the relationship eventually ending when he got older and started seeing girls his own age. She was not planning to stop. She was grieving the future inevitability of stopping. The second victim. When investigators expanded their review, they found evidence of a second child. John Doe 2 had been approached by Ma in 2020 when he was 11 years old. In court testimony, prosecutors said the 11-year-old had fled the room when approached. He recognized something was wrong and removed himself from the situation. That did not end Ma's contact with him. Investigators found records of communications between Ma and John Doe 2 beginning when he was 11, establishing that she had been pursuing a second victim on exactly the same model she used with the first. Ma was arrested in March 2023. She was initially charged in connection with John Doe 1 only. When the evidence regarding John Doe 2 emerged during the investigation, additional charges were filed. The potential sentence across all counts at maximum reached 165 years to life in state prison. Black ornament Jacqueline Ma received the highest professional recognition her county gives to educators in August 2022 and was arrested 7 months later. The judge at her sentencing specifically noted that the grooming had occurred in plain sight and was not recognized because she was a well-regarded and award-winning teacher. What does it say about our ability to protect children when the predator is also genuinely excellent at the legitimate parts of their job? Can both of those things be true about the same person at the same time? Tell me your honest take. The sentencing. On February 5, 2025, Jacqueline Ma appeared in court and entered a guilty plea to 2 counts of forcible lewd acts on a child under 14, 1 count of a lewd act on a child, and 1 count of possessing material depicting a minor engaged in sexual conduct. The plea agreement specified a sentence of 30 years to life, a reduction from a maximum possible in exchange for sparing both victims a trial. On May 9, 2025, she stood before San Diego Superior Court Judge Enrique Camarena in a Chula Vista courtroom, dressed in a blue prisoner's uniform with her hands shackled. She had prepared a written statement, which she read aloud while crying. She said she was deeply ashamed of her actions. She said she had manipulated and deceived the boys. She said the boys' families had trusted her, and she had betrayed that trust. She said she had exerted power and control over them and deceived them into thinking she was their friend. She said she had ripped away their childhoods. She said she had shamed the title of teacher. Neither of the victims attended the hearing. The deputy district attorney relayed the response of one of the boys' mothers on her behalf. The mother said she could not believe she had trusted Jacqueline Ma. She was otherwise speechless. Judge Camarena, before imposing the sentence, made an observation that has stayed with every person who has followed this case. He noted that the grooming activity had occurred in plain sight, that the true nature of what Ma was doing had not been recognized by the school, by the families, by the community that had celebrated her, because she was a well-regarded, award-winning teacher. He described what had happened to these boys not as a single lapse of judgment, but as a prolonged pattern of child sexual abuse. 30 years to life. She will not be eligible for any parole review for 3 full decades. The deputy district attorney noted that while the investigation had been exhaustive, he could not rule out the possibility of additional victims who had not come forward. Ma's defense attorney said his client had pleaded guilty because it was the right thing to do, and that she did not expect forgiveness from the victims or their families. There is a specific phrase in Judge Camarena's remarks that stays with you. The grooming activity occurred in plain sight, not in a basement, not in secret locations accessed after dark, in plain sight, on school grounds, in after-school sessions that parents knew about, through school communication apps the district had provided, in plain sight. The predator's most powerful tool was the assumption that a person doing these things at a school with credentials and an award certificate was safe. That assumption is what the investigation dismantled. That assumption is what 30 years to life reflects. The athletic trainer, McKinney, Texas, McKinney North High School, fall semester 2025. A 35-year-old athletic trainer named Lindsey Post works with student athletes at the school and provides support services at 2 middle schools in the same district. She has access to students across multiple campuses. Over a period of approximately 2 months, between November 2025 and January 2026, she systematically grooms a 14-year-old freshman at McKinney North. She builds his trust, tells him she has feelings for him, moves from verbal contact to physical contact on school grounds, and then, according to the lawsuit filed by the victim's family, removes him from campus in her car on multiple occasions to assault him. McKinney Police Department arrested Lindsey Post on January 28, 2026, after investigators received allegations of inappropriate text messages and conduct between Post and a student. She was charged with 2 second-degree felonies, sexual assault of a child and improper relationship between an educator and student. She was booked into the Collin County Jail and released after posting a $125,000 bond. The family of the 14-year-old filed a civil lawsuit against Post and McKinney Independent School District 2 days after the arrest. What the lawsuit describes. The civil complaint described the pattern of conduct investigators say Post followed from the beginning of the school year. According to the lawsuit, Post worked to build trust with the student over the first weeks of contact, gradually moving beyond the established boundaries for appropriate school employee-student interaction. The complaint says she told the student she had feelings for him. She began messaging him on his personal phone number, taking the contact outside the school systems into private channels. She hugged him at school. She kissed him at school. She then began, according to the lawsuit, taking him from campus in her car, where the assault occurred. The complaint alleges the pattern recurred multiple times. The civil attorney representing the family said in a public statement that Post had repeatedly taken this child away from the school and described it as among the worst possible violations that can happen to a child and a family. The lawsuit also names McKinney ISD as a defendant, alleging gross negligence in supervision. The district stated it had acted immediately upon learning of the allegations and had terminated Post following her arrest. The law enforcement angle. The McKinney Police Department investigation moved quickly from the initial complaint to arrest, a matter of weeks. The charges of sexual assault of a child and improper relationship between an educator and student are both second-degree felonies under Texas law, each carrying a potential sentence of 2 to 20 years in state prison. Because the victim was under 17 and the defendant was more than 3 years older, the charges qualify under the most serious applicable statutory provisions. The case is ongoing as of early 2026. No trial date has been set. Post is free on bond. The civil lawsuit is proceeding separately. The family's attorney said the minimum they are hoping for from the civil action is making schools significantly more reluctant to allow this kind of access and abuse to continue within their systems. The Lindsey Post case is the most recent in this episode, still active in the courts as of the time this script is written. Unlike the 3 cases before it, it has not yet produced a verdict or a sentence. Everything is alleged, and yet the pattern it follows, the trust building, the personal phone contact, the removal from campus, the use of a professional position to access a minor, is the exact same pattern documented in Arizona, Tennessee, and California. Does the consistency of the method across 4 completely separate cases, different states, and different years tell you something? What does that consistency mean to you? Drop it in the comments. What law enforcement sees? 4 cases, 4 different states, 4 different institutional settings, an Arizona elementary school, a Tennessee elementary school, a California elementary school, and a Texas high school. Time period spanning 2018 to 2026. Ages of victims ranging from 11 to 14 at the time grooming began. And 4 methods that, when laid out next to each other, are nearly identical. Step 1. Identify a child within the professional setting. A child who is responsive, trusting, perhaps slightly isolated socially, perhaps in need of a particular kind of adult attention or validation. A child who is accessible. Step 2. Use the legitimate tools of the professional relationship to begin building a private channel. Educational apps, video game chat, a school communication platform, an unofficial after-school program. Each one a legitimate thing that parents and administrators do not question because it looks exactly like what it is supposed to look like. Step 3. Migrate the relationship from the institutional channel to a personal one. Instagram, Snapchat, personal phone numbers. The platforms that disappear, that do not have institutional logging, that are harder to subpoena and trace. Step 4. Begin escalating the content and the access. Explicit photographs. Physical contact. Encounters arranged away from school, away from witnesses, away from the systems that might catch it. Step 5. Manage the risk. Use code words. Use hidden apps. Use threats, emotional leverage, and the power dynamic inherent in the adult authority figure-to-child relationship to keep the victim quiet. Tell them they will regret it if they tell. Tell them it is complicated. Tell them you may have blurred the lines. Law enforcement professionals who specialize in child exploitation cases describe this sequence in almost exactly these terms across investigations that have nothing to do with each other, conducted in different states by different agencies. The specific platforms change over time. The apps and gaming platforms of 2018 are different from those in use in 2026, but the architecture of the approach is consistent. The predator uses the legitimacy of their professional position as cover for the first steps, uses a communications infrastructure of modern teenage life for the middle steps, and uses the power differential inherent in the relationship for the final ones. How these cases got caught. Each of the 4 cases in this episode was discovered through a different mechanism, and the variation is instructive. Brittany Zamora was caught because a family installed a parental monitoring app on their son's phone. That app flagged content that the parents reviewed. The parents called police. Without the app, the relationship might have continued indefinitely. The school had received written report from multiple students 6 weeks before the arrest and had not immediately escalated those reports to law enforcement. Alissa McCommon was caught because a parent came forward after seeing communications on her son's phone. The investigation then expanded to identify 20 additional potential victims. McCommon's own post-arrest behavior, contacting her victim through a secret phone number, using their established code word, threatening him, provided investigators with additional documented evidence that she was fully aware of what she had done and was trying to suppress the victim's cooperation with police. Jacqueline Ma was caught because a mother found messages on a family tablet. The key detail, the victim's parent had specifically prohibited him from having personal electronics or social media. Ma constructed an alternative pathway through school tools and gaming platforms. It was on the family tablet, a shared household device, not the child's personal property, that the mother found the messages. One device the parents had not thought to restrict, because it was shared among the entire family and not associated with their son specifically. Lindsey Post was caught when the McKinney Police Department received what their statement described as allegations of inappropriate text messages and conduct. The The text message record was extensive enough to support 2 felony charges within the investigative timeline. There is also a 5th mechanism worth noting, because it appeared in the McCommon case specifically, the predator's own post-arrest behavior. When Alissa McCommon contacted her 12-year-old victim through a secret phone number while out on bond, when she used her established code word to communicate with him, when she threatened him and told him he would regret reporting her, she handed investigators a documented record of obstruction and witness tampering that made every subsequent legal proceeding more straightforward. The instinct that drove her to make that contact was the same instinct that had driven every step of the grooming process. The belief that she could manage the situation, control the communication, and override the consequences through direct engagement with the person most likely to affect her outcome. It failed in exactly the way you would expect. It failed completely. The common thread: someone saw something, or something was found, and law enforcement was called. The investigation that followed produced charges. The charges were serious enough to produce plea agreements or convictions. The outcomes: 20 years, 25 years, 30 years to life, and a case still working through the courts, reflect the legal reality that adults who exploit positions of trust over children face the full weight of the statutory frameworks designed for exactly that crime. The institutional blind spot. Female predators in trusted institutional roles occupy a specific blind spot in how communities and institutions process risk. The research is consistent. Reports about female educators are less likely to be escalated immediately. Students who report them are less likely to be believed right away. Parents who hear early warning signs are more likely to rationalize or minimize them. And the predators who understand this, who operate with full awareness of that cultural assumption, use it as part of the operational cover that allows them to continue. The school that received written reports about Brittany Zamora and waited 43 days before law enforcement was involved. The school where Jacqueline Ma ran an unsanctioned after-school program that no one questioned because she was a teacher of the year. The system that allowed Alissa McCommon to bond out after her first arrest without sufficient safeguards, creating the window in which she recontacted her 12-year-old victim through a secret phone number to threaten him. These are not failures of individual people making isolated bad calls. They are patterns in how institutions respond, or fail to respond, when the predator looks like the most trusted person in the room rather than the most dangerous one. Recognizing that pattern, naming it, and adjusting how institutions respond to reports about female educators is part of what makes it possible to catch the next case earlier, before it becomes a pregnancy, before it becomes a rearrest for witness tampering, before a detective has to explain to a parent what was found in a hidden app on a teacher's phone. Child exploitation investigators describe a specific challenge in cases involving female educators. The first report almost never comes from the primary victim. It comes from a parent who found something, from a second student who witnessed something, or from a digital trail discovered by accident. The primary victim, especially when the victim is a young boy and the predator is an adult woman, is often the last person to identify what is happening as abuse. The cultural narrative around relationships between adult women and teenage boys has historically framed these situations differently from how the law frames them. That framing is something predators are aware of and count on. It is part of why boys in these situations are less likely to report, more likely to be confused about whether they were harmed, and more likely to be reluctant participants in the prosecution that follows. Law enforcement professionals who work these cases describe it as one of the most significant investigative challenges in the field, reaching a victim who has been conditioned, through the grooming process itself, to protect the person who harmed them. All 4 of the cases in this episode have male victims. The legal framework treats what happened to each of them with the same weight it would apply to any other child in an equivalent situation. The sentencing outcomes, 20 years, 25 years, 30 years to life, reflect that legal equivalence. The investigations that produced those outcomes were driven by the same statutory frameworks, the same evidence standards, and the same prosecutorial commitment that would apply to any predator in any position of trust. The gender of the predator did not reduce the seriousness of the charges, the scope of the investigation, or the length of the sentences. It should not. It does not. And the cases that prove that are exactly the 4 cases you heard today. The 4 women in today's cases are serving sentences or facing prosecution that reflects the legal weight of what they did. The parents who found the devices and made the calls are the people who made these investigations possible. The people who saw something wrong and trusted their instinct enough to call police rather than explain it away. The children who live through these cases are people now. Some of them were elementary school students when this started. Some of them have their entire adult lives ahead of them, with this as part of their history. The sentences handed down in courtrooms in Arizona, Tennessee, and California do not undo that history. They produce accountability. They remove the people who created that history from access to other children. And they establish, in the public record, that the crimes these women committed were treated with the full seriousness they deserved. That matters. Even when it is not enough, it matters. If you are a parent watching this episode and thinking about your own children's digital world, the gaming platforms, the school communication apps, the social media that teachers and coaches and trainers have access to, the single most important thing this episode can offer you is this. The protective measures that worked in these cases were parental monitoring apps, shared devices that parents had access to, and the willingness to take a child's account of something that felt wrong. Seriously enough to call the police rather than explain it away or handle it internally first. Monitoring what your children communicate through is not a violation of their privacy. It is a protective layer that, in the Zamora case and the Ma case and the McCommon case, is what ultimately revealed what was happening and gave law enforcement the tools to respond. And if you are a student, a young person, watching this episode and recognizing something in what you heard, a teacher or coach or trainer whose attention feels different from how adult attention is supposed to feel, whose messages have moved from a school platform to a personal one, who has asked you to keep something private from your parents. The most important thing this episode can tell you is that the instinct that something is wrong when it feels wrong is worth acting on. Every single case in this episode eventually reached law enforcement. Every single case eventually produced accountability. The path that was difficult in every case. But it existed. It always exists. If this episode covered something you hadn't fully understood before, the grooming method, the institutional blind spot, the specific mechanics of how these cases get caught, share it with someone who should know. These cases deserve to be known. The families who lived through them deserve the acknowledgement that what happened was real, it was wrong, and it was prosecuted. Your thoughts, your questions, your pushback on anything in today's episode, all of it belongs in the comments below. I read every single one. See you in the next one.